Hello everyone and welcome back in part number 17th of the Bear Act. And in this video we will discuss from article 106 to 115. Let us take a quick revision first of each article, then we will discuss it in a detail and simplest possible way. Article 106 about salaries and allowances of MPs. That means who has the power, who has the authority to decide how much each MP will get as their salary. Apart from this, article 107 about the introduction and passing of a bill. As we all know that there are certain kinds of bill, right, like ordinary bill, money bill and constitution amendment bill, right? So all the important information related to the bills I am going to discuss here in this video. Apart from that, article 108 talk about the joint sitting of the both the houses, that means Lok Sabha as well as Raj Sabha, or more specifically about the house of the people and the council of the state. Article 109 is about the special procedure for the money bill to be passed, and article 110 about the definition of the money bill, that what type of bill constitute the money bill and who has the authority to decide that certain bill is belonging to a category of money bill or not, right? Article number 111 is about the assent of a bill by the president, assent to the bill. And article 112, as you all know, about the budget, but you will not find the mention of the word budget in the constitution. Instead of that, you will find the mention of the annual financial statement. Article 113, that means procedure in the parliament. If you want to demand the grants, then what procedures should you follow? Apart from this, article 114 is about the appropriation bill. Article 115 about the supplementary, additional of or excess grants. So all the important information related to these article I am going to discuss in this video, so stay tuned with me till the last, and I am making sure that the explanation that I am providing is basically keep it simple so that common viewers can also understand the Bear Act, right? Now let us move to article number 106, but before it let me tell you article number 105. So this article was about the power privileges of the houses of the members or the parliamentary committees, right? So this article talk about the power and privilege of the MPs or the members of the committee. Okay, now for today, article number 106, and this article is about the salaries and allowances of the members of the parliament. Who has the authority to decide how much each MP will get as allowances apart from allowances as a salary? So it is totally upon the parliament, and the parliament bylaw will provide the procedure or the how much money, how much salary, how much allowances will each MP will get. So who has the power? Parliament has the power. Parliament will decide. So MP's salary and allowances are decided through the law made by the parliament. So article 106 about the salaries and allowances of MPs. Okay, and article 105 was about the privileges, and there were two kind of privileges that I have discussed. One was about the collective privileges as a parliament, right? And second one was about the individual privilege. If you are an individual minister or member, then what kind of privileges that are available to you? Clear? Now move to article number 107, and 107 of the Indian Constitution is basically talk about the introduction and passing of a bill. Clause 1 of article 107 says that subject to a special provision relating to money bill and other financial bill, a bill may originate in either house of the parliament. That simple means an ordinary bill can be generally introduced in Lok Sabha or Raj Sabha, but as you all know, money bill can be only introduced in the Lok Sabha. Clear? So subject to the provision of article number 109, right, and 1017. 1017 about the financial bill and 1019 about the special procedure for the money bill. Okay, now a bill may originate in either house of the parliament. That means apart from these bill, an ordinary bill can be introduced in either of the house, whether it is in Lok Sabha or the Rajya Sabha. Okay, so this is clause 1 of article 107. Clause 2 is about that a bill is not considered passed by parliament unless both house agrees to it, either without amendment or with amendment agreed by both house, subject to article 108, that means joint sitting, and 109, that means a special procedure for the money bill. Clear? So for an ordinary bill, Lok Sabha and Rajya Sabha both must agree. Clear? And let's suppose if there is a certain circumstances where both the houses, Lok Sabha and Rajya Sabha, not agrees, then what will happen? Then there will be a joint sitting for the ordinary bill, not for the money bill or for the constitutional bill. That you should keep in mind the basic differences. Okay, so for the ordinary bill, both Lok Sabha and Rajya Sabha has equal power, both must agree, right? But for other bill I will discuss different procedure in subsequent articles. Okay, now clause 3 is about if suppose a bill is pending in parliament does not lapse Why? When the bill is pending in the parliament, when they will not lapse, merely because parliament is prorogued. There is a difference between adjournment and prorogue. Prorogue done by the president and adjournment done by the presiding officer. So no, a bill is pending in parliament and that bill will not lapse because parliament is prorogued, but there are certain conditions when the bill basically left. I will discuss it. So prorogation does not kill a pending bill. That is the main theory that you need to know, that you need to learn, that you should keep in mind, that merely a bill is pending in the parliament and the parliament is prorogued, or the session is prorogued, not parliament, session is prorogued, then merely because of that reason the bill will not lapse. That is the simple basis of article number 107 clause 3. So prorogation does not kill a pending bill. This one statement that you should keep in mind straightforward. Okay, so session in does not mean that bill automatically will lapse. Okay, so there are certain conditions, I will discuss it. Clause 4, if a bill pending in Rajya Sabha, if a bill pending in Rajya Sabha, and you all know that Rajya Sabha is a permanent body, it not subject to dissolution, clear, and has not been passed by Lok Sabha. Don't you think these bill will not lapse? Of course, because let's suppose when Lok Sabha will reunite or recession, then Lok Sabha can pass it. And if Raj Sabha is not subject to the dissolution, then it is not a matter that a bill will lapse. Simple. Okay. So bill does not lapse because of the dissolution of the Lok Sabha. But for that one condition is very very important, and the condition is that the bill should be pending in Rajya Sabha, not in Lok Sabha. Otherwise, it will lapse. Okay, because maybe new government that form after present Lok Sabha will no longer keen to pass that bill. Then what will happen to that bill? Clear? So if a bill is pending in the Rajya Sabha and does not pass by Lok Sabha, and that Lok Sabha is dissolved, then that bill will not lapse. Okay. So if a bill is pending in Rajya Sabha and Lok Sabha is dissolved, the bill will not lapse. Clear? So it is given under Article 107 Clause 4. Clause 5. Let's suppose if a bill is pending in Lok Sabha, don't you think this bill will lapse? Because let's suppose if new government, new party government will form, right? And that party is not keen to carry this bill, or they are not keen to pass this bill, right? So these bill will lapse. Clear? So if a bill is pending in Lok Sabha or a bill passed by Lok Sabha but pending in Rajya Sabha, generally lapses when Lok Sabha is dissolved subject to Article 108, that means joint sitting. So if a bill is pending in Lok Sabha, but also one more important thing, even the bill passed by Lok Sabha but it is pending in Rajya Sabha, these bill will lapse. Clear? So bill pending in Lok Sabha and Lok Sabha dissolved, then that bill will lapse. Simple. But if a bill is pending in Rajya Sabha and the bill is not introduced in the Lok Sabha, then that bill will not lapse. Clear? So bill passed by Lok Sabha but pending in Rajya Sabha, also dissolved. So two conditions. One, that bill is pending in Lok Sabha, and second, bill is passed in Lok Sabha but they are not passed by Rajya Sabha. Then what will happen? That bill will lapse. Clear? But there is an exception. Now let's suppose if president notifies joint sitting for that disagreement, then that bill will not lapse. Okay, that bill will not lapse if president notifies the joint sitting for that matter or that bill, then that bill will not lapse. So there is an exception as well that you should keep in mind. Clear? So Article 107 has various provision, 5 provision I have discussed. One was ordinary bill, and both house, Lok Sabha and Rajya Sabha, must agree upon that. If there is disagreement, then there can be joint sitting for that matter. And clause 2 was about that it should be agrees with amendment or without amendment. That is Article 107 clause 2. But in Article 107 clause 1 about the introduction of the bill, right? That ordinary bill can be originate in either house, either Lok Sabha or Rajya Sabha. That you should keep in mind. And clause 2 was about the with amendment or without amendment, a house may be agreed upon. 3. Clause 3 is about the lapsing of the bill. So if a bill pending in parliament, then that bill will not lapse just merely because of the Lok Sabha is prorogued. Clear? And article number 107 clause 4, that if a bill pending in the council of state, that means in the Rajya Sabha, but it is not passed by Lok Sabha, then that bill shall not lapse. But clause 5, if a bill is pending in Lok Sabha or even passed by Lok Sabha but it is pending or not introduced in Rajya Sabha, then that bill will lapse. But let's suppose if president notifies joint sitting, then that bill will not lapse. That is the important point that you should keep in mind while dealing with article number 107. So 106 was about the salaries and allowances of the member of parliament. 107 was given about the bills, right? How bills can be introduced, in which house a bill can be introduced, and how joint sitting can take in place. So all the related information about the bill, ordinary bill, is discussed under Article 107. Even the about the lapsing of a bill also. Article 107 about the joint sitting of the both houses. But this device is not available for the money bill in constitutional amendment bill. Clear? Joint sitting is not available to these two kinds of bill. Clear? So a joint sitting may be called when there is a disagreement between the two houses regarding a bill, such as rejection by other house, disagreement over amendment, or failure to pass the bill for more than 6 months. So what are the conditions that ultimately led to joint sitting? The first condition is disagreement about any clause or subclause. Second condition, if a house suggested any amendment, but other house who introduced the bill does not keen to keep that amendment or to keep that suggested amendment, then it can also lead to joint amendment. Sorry, joint sitting. So this is called amendment. And the third is the other house is not responded within 6 months. If there is a time more than 6 months, greater than 6 months. So these are the certain conditions that are mentioned in the Constitution of India and that led to the joint sitting of the parliament. So first one is disagreement over general clauses, and if other house suggested some amendment and the other house is not agrees upon, then it could also lead to joint sitting. And the third one is about the more than 6 months have elapsed. That means one house sent the bill to other house and it has been 6 months that other house do not take any action. Clear? Then joint sitting can be of both the houses. So these are the conditions that are mentioned in the article number 107 that you should keep in mind. So if Lok Sabha and Rajya Sabha can't agree on an ordinary bill, the president may call a joint sitting. Clear? Now, joint sitting is not available for a money bill that I have already told you. Clause 2. Who has the authority to notify the joint sitting of the both houses? Then it is available to president. The president may notify the house of the intention to summon them for a joint sitting in the situation specified in the clause first that I have discussed three situations when there can be a joint sitting. Clear? So who has the authority? President have authority to notify joint sitting. Clear? Now when the constitutional conditions for a joint sitting arises, the president can notify parliament or president can summon the parliament for a joint sitting. Clear? Clause 3. The speaker of the Lok Sabha or in specified circumstances, deputy speaker or another person will determine under the constitutional rule preside over the joint sitting. As we all know that Lok Sabha presided by the speaker and in the absence of the speaker, deputy speaker. In the case of the Rajya Sabha, that means Council of State, chairman or more specifically vice president presides. In absence of that, deputy chairman presides. But in the case of the joint sitting, who is going to preside this joint sitting? So article number 108 clause 3 says that it will be the speaker of the Lok Sabha. So speaker of the Lok Sabha will preside. And let's suppose if speaker is absent, then who will preside? Then deputy speaker will preside. And let's suppose if deputy speaker is been absent, then any other person determined will preside over it. But you will not find the mention that joint sitting is presided by chairman or deputy chairman. Because why not chairman? Because chairman is not a member of the parliament, or you can say more specifically Council of State or the Rajya Sabha. Okay, so who will preside? Speaker. Is it mentioned in the Constitution? Yes, under clause 3 of the article 108, that is mentioned in the Constitution. Who has the authority? President has the authority to notify the joint sitting. Where it is mentioned? It is mentioned under clause 2 of article 108. Clear? So joint sitting is essentially presided over by the Lok Sabha speaker or the person authorized under the relevant rules. Provision clause 4. The joint sitting is conducted according to the rules made for that purpose. That means parliament can make a law, can make a rules for the joint sitting. As you all know, for the transaction of the business or to carry out the transaction of the business of houses, each houses has its own rule. Lok Sabha has its own rule, Rajya Sabha has its own rule. But which rule will apply when there is a joint sitting? So that power of the making rules lies with the parliament. So the parliament will make the rules to govern the joint sitting. Clear? It is mentioned under clause 4 of article 108. Clause 5. A joint sitting may take place even if Lok Sabha has been dissolved after the President has already notified the intention to summon the House. So let's suppose President already notifies that there will be a joint sitting for this matter, and then after that Lok Sabha dissolved. Then what will happen? Can be there a joint sitting? Yes. So there will be a joint sitting even after Lok Sabha dissolved. Clear? So the President has already notified, but the condition is President already notified it before dissolution of the Lok Sabha, then joint sitting will take place. Clear? That is the clause 5. So as you can see, 108 contain 5 clause, 1, 2, 3, 4 and 5. One was about the if a bill, let's suppose, passed by one houses, then what are the certain grounds or the certain condition that can lead to the joint sitting? So first is rejected by the other houses, more than 6 months have elapsed, and if there is an amendment suggested by other house but the first house not agrees upon that. So there are certain 3 conditions are mentioned under clause 1 of 108 article. And at clause 2 was about the summoning of the house for the joint sitting. Who has the authority? President. Clause 3. Okay, so clause 3 was about, but one more important thing that I want to tell you here. Yes, clause 3 is about who will preside over. So it is the speaker who will preside over. Clear? In the clause 4, rules made by the parliament. Clear? And the clause 5 is about the if Lok Sabha dissolve, but before its dissolution, President notifies the joint sitting, then there will be a joint sitting for that. Clear? Now let's move to article number 109 about the special procedure for the money bill. That what UPSC has asked question regarding this article in the prelims, and most of the student has marked it wrongly because they do not know about the article number 109 that mention the procedure for the money bill. Clear? So a money bill shall not be introduced in Rajya Sabha. That means it can be introduced only in the Lok Sabha. So money bill only can be introduced in the Lok Sabha. This is mentioned under clause 1 of the article number 109. But as I have already told you that you will not find the mention of Rajya Sabha or Lok Sabha. You will find the mention of basically Council of State or the House of People. Clear? Clause 2. After Lok Sabha passes a money bill, then what will happen to money bill? It will send to the Rajya Sabha. And the Rajya Sabha has 40 days period. Clear? And Rajya Sabha has must return money bill within the 40 days. So it's sent to Rajya Sabha for recommendation. Rajya Sabha must return it within the 14 days. Clear? So the period that are mentioned for the money bill to be reserved by the Rajya Sabha is basically 14 days. Clear? So Rajya Sabha can give the recommendation, and it is totally upon the Lok Sabha whether Lok Sabha wants to agree on that amendment or not. And if they not, they can even consider it as a pass and not reject the money bill like an ordinary bill. That means Rajya Sabha has no power to reject the money bill. It can only make the recommendation. Clear? So Lok Sabha may accept or reject those recommendations. That is totally depend on the Lok Sabha. Clear? So money bill can be introduced in Lok Sabha, clause 1 of article 109, and 14 days maximum period is about the money bill that is available to Rajya Sabha mentioned under clause 2 of the article 109. Clear? Clause 3. Let's suppose if Lok Sabha accept Rajya Sabha recommendation, then the bill deemed to be passed by both the houses with those accepted amendment. That means if Council of State or Rajya Sabha suggested some amendment and the Lok Sabha agreed upon that amendment, then it's not a need to send it again to the Rajya Sabha. No. If Lok Sabha accepted that recommendation, then that bill deemed to be passed by both the houses. It is not necessary to resend it again to the Rajya Sabha that yes, I have accepted your recommendation. No. Clear? So Lok Sabha accept the recommendation, then bill pass with those changes. Clause 4. If the Lok Sabha does not accept the recommendation, then what will happen? Then also bill is deemed to be passed in form of originally passed by the Lok Sabha. So if even after accepting, the bill will not resend to the Rajya Sabha, and even after rejecting the amendment, that means also that bill will not resend to the Rajya Sabha again. So maximum time available for the Rajya Sabha to act on the money bill is 14 days. Clear? Lok Sabha can simply reject Rajya Sabha's recommendation. Clause 5. If Rajya Sabha does not return the money bill within 14 days, then also bill is deemed to be passed. Okay, so there are 3 conditions. The first condition is that amendment. If Lok Sabha accept amendment, then that bill deemed to be passed. If Lok Sabha rejected amendment, then that will also be deemed to be passed. And if Rajya Sabha do not take any action or do not return the money bill within 14 days after passing in their house, then also bill be considered deemed to be passed. Clear? As you all know, it can't return for the reconsideration, or even Rajya Sabha cannot reject the money bill. Clear? So these are the conditions that you should keep in mind: 3 clause, 4 clause, and 5 clause. So Rajya Sabha does not return it within 14 days, then also money bill is deemed to be passed. So money bill, Rajya Sabha has 14 days plus recommendations only has the power. Okay, they can make recommendations only, and it's totally upon the Lok Sabha to agree upon that recommendation or not. Clear? So it also contains 5 provision that you should keep in mind. Article number 110, definition of the money bill. Clear? So a bill is a money bill if it contain only provisions dealing with the matter is specified in this article. So whatever the matter contained in the article, there are certain list given in the article number 110, and if the bill is related to that matter, that bill will consider as a money bill, like imposition, abolition, remission, alteration, or regulation of the taxes, right? Apart from regulation of the borrowing of the money, custody of the consolidated fund or contingency fund, appropriation money out of the consolidated fund. Clear? Receipt of money on account of consolidated fund. Clear? So there are certain matters that are mentioned under Article 110. And if a bill introduced regarding that matter, that bill will consider as a money bill. And who has the authority to decide whether a bill is money bill or not? That authority lies with the speaker. That means presiding officer of the Lok Sabha, because it can only introduce in the Lok Sabha. Clear? So a money bill will consider only money bill if it is related to the matters that are mentioned under Article 110. So money bill is a bill only when it deals with the constitutional specified financial matter. So there are certain lists that are given. I am going to discuss here few, like clause 1A about the abolition, imposition, remission, alteration, or regulation of any taxes. Okay, so bills dealing with tax, impose, remove, reduce, change, or regulate the tax. This type of matter will consider as a money bill. Clear? 1B about regulation of borrowing of money by the government of India or giving guarantees by the government or amendment of the laws relating to financial. So these are the certain matters that are mentioned here, and if a bill introduced regarding these matters, then that will consider as a money bill. That is what you should know. Clear? 1E, 1F, everything I have mentioned. If you want to read it out clearly. Clear? Clause 2, if a bill is not a money bill. Why? Mainly because it imposes fine, pecuniary penalties, license fees, fee for services, or because it deals with the local taxes. Means just because a bill involves money, fees, or fine, it does not automatically consider as a money bill. No, the matter that are mentioned under Article 110, if a bill is related to that matter, that bill will consider as a money bill. Clear? So all the types of, as you all know, all the financial bill are not considered as a money bill, but all the money bill is considered as a financial bill. That you should keep in mind the basic difference. So if a question arises whether a bill is a money bill or not, the decision of the speaker is final. Clear? So who has the authority to decide certain bill is a money bill or a basically ordinary bill? That power lies with the speaker. That is mentioned under clause 3 of the Article 110. Clear? I hope clear. Article 111, that means assent of the bill. Now when a bill passed by the Lok Sabha and the Rajya Sabha both, then it sent to the President of India. Now President, for the ordinary bill I am talking about, has the some devices that are available with the President. One is that he can give assent, or even he can withhold assent, or he can return it for the reconsideration. And in this case, if the President returns the bill for the reconsideration, clear, and again the Parliament passes with same clause, same provision, then it becomes binding for the President to give his or her assent to that bill. Clear? So when a bill presented to the President may either give assent, withhold assent, or for a bill other than money bill, this device, all the device that I have discussed, not available for the money bill. Clear? The President may return it once for reconsideration, and if the Parliament passes it again with or without amendment, then President shall not withhold his assent. That means he is now obliged to give his or her assent to that bill. So these are the basic conditions that are mentioned under Article 111. Clear? So for an ordinary bill, President can return it once, and if Parliament passes it again, then it becomes binding on the President to give his or her assent. Clear? A money bill can't be written for reconsideration under this provision. Clear? So it is about the assent of the bill that are mentioned in the article number 111. Clear? 111. That means essence of bill. Now let's move. One of the most important articles of the Indian Constitution is article number 112, and it is about the annual financial statement, or more specifically budget. and it has various provisions that I am going to discuss about the budget. Clause 1. The President shall cause to be laid before both houses of Parliament a statement of the estimate receipt and expenditure of the Government of India for a financial year. So, who has the authority to represent the budget in the Parliament, or to present more specifically the budget in the Parliament? That power lies with the President, not with the Finance Minister. Finance Minister present budget in the Parliament on the behalf of the President. Clear? So if the question asks that who has the real authority to present the budget in the Parliament, that power lies with the President, not with Finance Minister. Finance Minister is doing this because on the behalf of the President. That you should keep in mind. Clear? So it is completely and explicitly mentioned under Article 112 Clause 1. 112 Clause 1. Clear? So this is the constitutional basis of the Union Budget or Union Financial Statement. But what it contains? It contains estimate receipt and estimate expenditure of the financial year. So income plus expenditure for upcoming financial year. And who has the authority to present? President. But who present actually? Finance Minister on behalf of the President. Clause 2. The statement distinguishes expenditure charged on the Consolidated Fund of India from other expenditure and separately source expenditure on the revenue account. That means the budget must distinguish what is charged expenditure that upon the Consolidated Fund of India and what is other expenditure except charge expenditure, and also budget must show revenue expenditure separately as well. Clear? So the statement that should be in the budget that should distinguish expenditure charge on the Consolidated Fund of India and some other charges that should clearly mention in that budget. Clause 3. Certain expenditure are charged on the Consolidated Fund of India. So these are the some matters upon which the expenditure are charged on the Consolidated Fund of India. That means there is no need of the approval of the Parliament to carry out that transaction, or you can simply say that for the expenditure like salaries, allowances of certain constitution of officer. This type of expenditure do not need the approval of the Parliament. That is the simple meaning of charge on the Consolidated Fund of India. Debt charges, salaries and pension of the Supreme Court judges, salaries and pensions of the CAG, certain court or tribunal judgments, other expenditure declared by Constitution or Parliament by law. So these expenditure are paid from Consolidated Fund of India, treated differently from the voted expenditure. That means yes, it can be discussed, but it can't be voted. It can't be voted. Clear? That is simple. So charge expenditure not voted by the Lok Sabha. So these are the some clauses that are mentioned under Article 102. President, what should be in budget, and what is charge expenditure on the Consolidated Fund of India. Article 113. Procedure in Parliament with respect to estimate. That what procedure should be followed. So clause 1 of the Article 113 is about that expenditure charged on the Consolidated Fund of India is not submitted to the vote of the Parliament, although it may be discussed. That's what I've already told you, that the expenditure that is for the charge on the Consolidated Fund of India, that expenditure should not be voted in the Parliament, but it can be discussed. Clear? So charge expenditure can be discussed but can't be voted upon. Clause 2. Other expenditure is submitted to the Lok Sabha in the form of demand of grants in the Lok Sabha other than charged expenditure may assent, refuse or reduce the amount specified. That means houses can act on that charges if the charge is not related to the charge on the expenditure on the charge expenditure on the Consolidated Fund of India. So other related can be discussed, can be voted, can be curtailed. That means action can be taken on that particular charges. So other expenditure like demand for grants, Lok Sabha will vote upon that. Lok Sabha can accept, can reject, can reduce the demand. Clear? Because it introduced in Lok Sabha. Clause 3. No demand for grants shall be made except in the recommendation of the President. That means it is necessary to obtain the recommendation of the President to grant or to demand for a grant. Clear? So if you need a grant, then President's recommendation is necessary under clause 3 of Article 113. Clear? So I have discussed clause 3. 1 is charge, that expenditure charged on the Consolidated Fund of India should not be voted in the Lok Sabha or the Parliament, but it can be discussed. And the clause 2 is about the other charges except the charge on the Consolidated Fund of India. They can be discussed, they can be curtailed, or whatever action required they can be taken by the Lok Sabha. That means accept, reject or reduce. And 3, that means without recommendation of the President there will be no grant can be made. That is simple thing. Clear? Now article number 114 about the appropriation of the bill. Lok Sabha, or more specifically central government, can't take out money from the Consolidated Fund of India for their expenditure if central government or government is not passing the appropriation bill. So it is mentioned in the Constitution that to take out the money from the Consolidated Fund of India, what you need is appropriation bill. So After grant under Article 113 have been made, a bill is introduced to authorize withdrawal of the money from the Consolidated Fund of India. So, grant made by Lok Sabha and it is expenditure charged on the Consolidated Fund of India. So, let's suppose after Parliament approves the required expenditure, then they need a appropriation bill. And that appropriation bill will give legal authority to withdraw the money from the Consolidated Fund of India for the expenditure. So, to carry out the money, to take out the money from Consolidated Fund of India under Article 114, it is necessary to introduce appropriation bill. Clear? Clause 2. No amendment can be proposed to an amendment appropriation bill that would vary the amount of a grant or alter the destination of the grant or vary charge expenditure. That simple means Parliament cannot use an appropriation bill to change the amount of approved grant to destination of the grant or charge expenditure. So no, after introducing appropriation bill for certain expenditure, you can't make changes, you can't manipulate that. That is the simple meaning. And if you, let's suppose you got a sum of money for the any plan, let's suppose, but if you think that plan is not sufficient, that is I'm going to discuss in Article 114 supplementary grant or excess grant. But if you think that I can take out money from the Consolidated Fund of India by just introducing appropriation bill, then no, you can't do that, right? So you can't do that. Clause 3. No money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law subject to Article 115 and 16. That means the government simply can't withdraw money from the Consolidated Fund of India. They need a appropriation bill. That's what I have discussed. And last article for today. Article number 115. Supplementary, additional or excess grant. That's what I have already discussed. Clear? So you can't use appropriation bill, no, but you can't use these devices. So President shall cause the necessary statement or demand to be laid before Parliament when the amount authorized for a particular service is insufficient or additional expenditure on a new service is not contemplated in annual financial issue become necessary. That means, let's suppose if there is a grant for certain scheme and the grant is not enough now, there need a excess amount or that amount is insufficient, then president has the authority. Okay, so president has authority. On approval of the president, you can take out the money by introducing grants in the houses. Clear? So if there is insufficient money or additional expenditure, when there can be additional expenditure, when a new service is necessary to be introduced, that's need additional expenditure and that you had not mentioned in the annual financial statement, that needs additional expenditure or additional grant. So supplementary grant, insufficient money or insufficient fund, and additional grant for the new services. Okay, so if the approved amount is not enough, then supplementary grant can be there. If money is required for new service not included in budget, then there can be additional grant as well. Clear? Now money has been spent on a service during a financial year in excess. If there is an excess amount granted for that service, then if the government has already spent more than amount originally granted, then there can be excess grant. Clear? So if there is an insufficient of money, then there can be supplementary grant. If new service, then there can be additional grant. If you have spend excess amount, then there can be excess grant. Clear? So these are the devices that are available for the unforeseen expenditure. The provision relating to financial procedure in demand for grants apply to these grants are applicable under the Constitution. That means like supplementary grant, additional or excess grant must follow the constitutional parliamentary procedure. That means you have to pass the bill. That is what you need to keep in mind. Let us take a quick revision, then wrap up this class, because I have discussed more than 40 articles including sub clauses, right? So article number 105 was about the parliamentary privileges, individual and collective. 106 was salaries and MP, that should be decided by the law made by the parliament. Article 107 introduction and passing of the bill, and it also included lapsing of the bill. Article 108 about the joint sitting, parliament has the power to notify the joint sitting, and there are certain conditions mentioned in the constitution that can lead to the joint sitting. Money bill procedure under article 109, definition of money bill. 110 president assent. 111 annual financial statement. 112 demand for grant is 114, and where is appropriation bill mentioned under article 114, and supplementary grant, additional grant and excess grant is mentioned under article 115. But here I have given a most important article for the UPSC perspective. So 107 about the ordinary bill. Clear? 108 joint sitting. Money bill definition contain 110. Clear? 110 talk about what is money bill. 109 about how it is passed, and 111 president assent. So let me know in comment section how was this lecture after watching. Clear? And let me know if you want any kind of improvement, then you are welcome in the comment section, and let's meet in next video.